Hi, good afternoon. Welcome and thank you for joining us for the third session of our Community Associations Building Blocks webinar series. Today's session will cover the topic of architectural review committees. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith, and I'll be your moderator this afternoon. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides during this webinar, and we think it will be helpful for you to be able to see both our videos and the slides at the same time. To do this, you may need to make one adjustment to your view settings. If you cannot currently see both the title slide for the presentation and my video, please find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose side-by-side mode. The slide deck should appear on the left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size for each view. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Our speakers today are also happy to take questions. If you have a question, please type it in the Q&A box and we will address it at the conclusion of the presentation. Please note, due to NC bar requirements, we will not be able to respond to community-specific legal questions during this session, but we can address general questions regarding the presentation subject matter. So let's get started. I'll go ahead and introduce our speakers. Today's speakers are Eric Remington and Alan Trask. Eric's practice experience encompasses various areas of civil litigation, including real property, business, and commercial litigation, zoning and land use issues, disputes involving community associations, and insurance coverage disputes. He is a member of the Zoning, Planning, and Land Use Section Council of the North Carolina State Bar Association and leads the firm's eminent domain practice. Alan works with North Carolina real estate developers and the community associations that they create to handle a wide range of issues, including the preparation, amendment, interpretation, and enforcement of restricted covenants and governing corporate documents, declarant control transition and disputes, fiduciary concerns, and collections. His work with real estate developers also embraces land use and zoning matters and commercial property management concerns. I'll turn the mic over to Alan and we can begin.
Thanks, Jen, and welcome everyone. We're so happy that you're here with us today. Again, I'm Alan Trask. I help co-chair our community associations group here and have practiced with Eric for a decade. He's been a mentor of mine. And so between the two of us, we've got a lot of experience in these matters. We've seen kind of the whole role of it. And we were actually talking earlier today, a great deal of the litigation cases that we both deal with in the HOA space are actually about architectural review disputes and concerns. You know, architectural review really is one of the most fundamental day-to-day things that community associations find themselves dealing with, and also one of the ones that is complicated, a little hard to understand, and breeds a lot of controversy. And so today we're hoping to walk you through the process, talk about the authority for architectural review, the procedure for how it's handled, and we'll touch on the enforcement of those restrictions. And we wanted to sort of share some of our experience and see if we can't pass along a little bit of what we've learned, you know, so that we can get these community associations working proactively to avoid some of these disputes. So I know it seems elementary, but we really should talk about the priority of control of governing documents. As you all know, community associations are governed by a set of governing documents and North Carolina law. But speaking specifically to the governing documents, there are a bunch. And folks that are in community associations understandably confuse and conflate these different sources of authority, and there is a hierarchy. And so we wanted to talk a little bit about each one of them and where they fall in that hierarchy and what the role is. So you're all familiar with the Declaration of Restrictive Covenants. That's often, just called the Declaration, certainly by the lawyers. That's the document that is recorded with the County Register of Deeds that actually determines the structure of the community, and restricts the use of an individual property within the community. That's really a key point, because when we're talking about architectural review, we're talking about the restriction of a freedom that would otherwise exist if the person owned a piece of property outside of the community association. So it's really important to know that the declaration is where you find those types of restrictions. A supplemental declaration is just a document that comes after a declaration, often adds property to the community. Supplemental declarations come in the form of an amendment, and you may see other amendments in the chain of title that would add to, change, or replace provisions of the original declarations. It's important that you're looking at the whole universe of amendments in the record. The Articles of Incorporation are on file with the North Carolina Secretary of State. That's the document that actually creates the community association, and it's important to review it. Sometimes it's very short and to the point, but oftentimes there are some provisions in there that actually govern the operation of the company. And when we're talking about the company, we're talking about the homeowners association. The bylaws are a document that governs corporate procedure. It's really important to understand that, as the primary role of bylaws is to govern corporate procedure, things like meeting quorums, voting procedures, that sort of thing. There are instances where the bylaws are incorporated into the declaration by a specific covenant, or in the case of very old condominiums, the bylaws actually can form a part of the governing documents. But it's better to walk in with the assumption that the bylaws are secondary to the declaration. Restrictions and rules are most often board-imposed restrictions and rules on common area. Things like the pool, the tennis courts, the parking lot, stuff like that. There are times where rules and restrictions can apply to individual lots, but it's got to be specified in that declaration. Design guidelines, similar, are really not so much restrictions in their character as they are a statement of interpretation of the restrictions that are in the declaration. And we're going to come back to a lot of this. Board resolutions and policies are really just an agreement amongst the board as to how they're going to conduct themselves. So it's really important to understand the difference in all these pieces of authority, because what we found over the years is that architectural restrictions seem to find their way into all different sources of the authority, and where they rest determines how enforceable they may be.
Hey, thanks, Alan. My name is Eric Remington, and appreciate the kind words from Alan as being his mentor. I've been doing this for a while, and I consider us more of a team. We have a great community associations practice group, and a lot of attorneys that participate in that, and we often share war stories a lot about some of the different types of incidents that we get involved in with community association groups. And like Alan said, there's a lot of them that are related to architectural control and how either the board or an architectural control committee handles those type of situations. Now, Alan has talked to you a little bit about the documents that are created once a community is created and that are filed with the Register of Deeds. But over and above that, the question is, where does the board's authority truly come from to handle these kind of situations? And there's really two statutes that give the board power over architectural review. The first one is, depending on whether you're in a condominium complex or whether you're in a planned community, is Chapter 47F for planned communities and Chapter 47C for condominiums. And then the other one is the general statutes that deal with nonprofit corporations, which is Chapter 55A. So, you can see on the presentation that we've got Chapter 47F-3103A and 47.3-3103A provide that, except as provided in the declaration, bylaws, or articles, the executive board basically acts in all instances on behalf of the association. Now, for those two statutes, it's not retroactive to planned communities, but it is retroactive to all condominiums. So it depends on when you're your planned community was created as to whether it applies to you. But then there's Chapter 55A, which also states that all corporate power shall be exercised under the authority of and the affairs of the corporation managed by the board of directors, except as, again, provided in the articles of incorporation. And that's why Alan went over that hierarchy of documents, because you need to know where to start your looking and what to look at and what order to look at them to determine what powers the board has and what powers the architectural committee has. Some of these documents that are created as a result of these two statutes, including the documents that Alan's talked about, are going to give powers to the Architectural Control Committee to control the architectural process. Despite the fact that these statutes give the board's rulemaking authority, there has to be some sort of a provision within the declaration that allows the board to regulate on-lot architectural standards. Because as most of you all probably are aware, community association boards and the community association itself is typically only responsible for maintaining operating and repairing the common areas and common elements in the community or in the condominium association. And so the board typically only has policy and rulemaking authority over those matters that deal with common elements and common areas. So it's like Alan said, typically the law favors the free use of property. And so in order for there to be control over architectural standards within a particular person's lot, there has to be some sort of specific delegation of that authority in the declaration when it's created. Architectural control committees and the rules that they are going to operate under can be more detailed than the declaration if the board has that authority to make rules and regulations for architectural control. But they can't expand the scope of the authority to be inconsistent with the declaration. So as you can see, one example would be square footage for heated space. Let's say your declaration says that you can build a house that's a minimum of 2,500 square foot of heated space. The guidelines that the board creates can't basically narrow the scope of that to say, oh no, you've got to build one that's larger than 3,000 square feet of heated space. So that's the type of regulations that you'll see sometimes are created in bylaws or in articles of incorporation or something other than the declaration, the architectural rules and regulations, but those typically are found not to be valid if they are more restrictive than the what's in the declaration.
So if you've noticed, one thing that we're fond of is making sure that you as a community association are on good ground before you actually start enforcing something. And this bullet point list that you see in front of you is something of an initial lawyer's checklist. And if you are faced with an adversary in the community, a member who is resisting enforcement, and they get an attorney, you better believe that these are the questions that the attorney is going to try to answer for themselves first. So we've talked a lot about the hierarchy of the documents, and just a threshold question is that rule or is that guideline, is it consistent with what the governing documents say? Eric gave a great example about trying to expand a minimum heated square footage. Same thing applies to setbacks, landscaping, anything like that. If the declaration allows for live oak trees throughout, but the board later adopts a restriction against live oak trees, I mean, that's the type of thing that can get a community association in trouble. When let's assume that the rule is consistent with the governing documents, the next level or layer of that analysis is, did the association have the authority to adopt the rule or the guideline? And this is something we see all the time as a problem area. The reason is because people consistently say, this is the way we've always done it. This is a practice that we've always had, a course of dealing, so to speak. The reality is that authority needs to be in the governing documents, and preferably, most preferably, in the declaration itself. So let's assume that it's consistent, the rule or guidelines consistent with the governing documents, and that the association had the authority to adopt it. Was it properly adopted? And here's where we're talking about corporate procedure. Was there a meeting called? If it was to be adopted by the board, was there a proper meeting called? Was there quorum at the meeting? Was a vote taken? All those boxes that have to be checked for a real corporate action. That's sort of the next thing that's going to be evaluated. And if all of that checks out, then whether or not this is a practical thing that can be enforced is important, because taking on something that's impractical is just a recipe for troublesome enforcement. There are all kinds of examples about things that are not practically enforceable. The height of grass at 1 1/2 inches on Bermuda grass. You know, that is something I have actually seen before. And you know what? It was absolutely impossible to enforce. Not only would you look ridiculous out there with a ruler, but the way grass grows and the cycle of it, that's just not something that's ever going to be enforceable. So we touched on this a little bit when we're talking about, the authority to adopt a rule or an ARC guideline. Look to see what the declaration authorizes. Hopefully the language is clear. If it's not clear, then you'll see the third point there is and you want it to be more clear, which is a good strategy to have. Look at amending those governing documents to get it to where it needs to be. If it's silent, proceed with serious caution, because silence is not a void that can be typically filled with regulation. So in my opinion, and in the opinion of a lot of the folks that work in our practice group, if the declaration is silent, that means that you can't. And so these are opportunities to amend the governing documents. All communities need to be looking at their governing documents all the time to make sure that the documents are consistent with what's actually happening in the community. If they're not, the documents need to be brought up to meet that place where the community finds itself. But amending the governing documents is a necessary step if you don't have the authority in the governing documents. You can't read it in. That's just not how it works.
So we've talked a bit about some of the procedures for adopting architectural guidelines and where the sources of those come from. And as Alan and I have both said, the main source of this is going to be your declaration, because most of the times the declaration is the document that's going to include guidance as to who's going to have the power to determine architectural rules, whether it's going to be the board or whether it's going to be a committee that is formed by the board. A lot of times, if those committees are formed, they're going to be formed ahead of time by the developer, because the developer is going to be in control of the board and the architectural review committee for the time that the developer is involved in it. But those documents, the declaration in particular, are also going to give you more specifics typically about the procedures that the architectural review committee has to follow, or the board has to follow if it's the board making the decisions. Typically what we see is that procedures for adopting architectural guidelines are generally that it takes a majority vote of the board or the committee to basically set up the rules, or you can do it by uniform written consent of either the board or the architectural committee. And again, whether it's the board or the architectural committee, That's going to be determined in the declaration. And a lot of times the declaration may say that the board has the authority to delegate that power, or it is already delegated through the document itself to a architectural review committee. Sometimes the documents will include a provision that says that there has to be approval by the members for certain things. That in my experience, that is not typical. Alan may have had different experience with that, but typically approval of the members for the architectural guidelines and things is not set up generally that way. So, remember, the main thing here is that you need to check your declaration, and the board is going to probably have some sort of authority to create rules and regulations or to delegate that to an architectural review committee that can then create those rules and guidelines.
So when you're talking about, approval of an application to do something, you've looked at all the things that we've talked about, and now the member is asking for approval. It's really important to understand that process and have it mapped out. I have actually drawn it on a whiteboard in certain communities where you have layers of associations and things like that, and delegated authority. But it's important to understand that process as board members, as managers, and then it's also important to understand it if you have an architectural review committee in place. Who makes the threshold decision or that initial decision? Is it an appointed architectural review committee? Is it the board? Is it the board if a committee is not appointed? Do you want to go ahead and appoint a committee to be in that space? Who does it? If the declaration is silent as to that, then the default should be that it is the board that makes that decision. If you want, as your community, to change that, then again, going back to amending the documents to get them where they need to be. The appeal process is really something that I want to touch on because I see this get messed up all the time. An appeal is a review of a decision, and in the lawyer world, a review of a decision by someone that didn't make the decision. So there's a difference between an appeal and a reconsideration. So if you have an architectural review committee that makes a decision, say they deny an application, there's no such thing really as an appeal back to that architectural review. What you could have is another application for the same review with a request for reconsideration. Like, hey, we know you denied it the last time, we're asking you to reconsider. Now, what an appeal would look like is if the architectural review committee denied the application and then the aggrieved member appealed that decision to the board of directors. Oftentimes, the declaration will have a procedure for this. It needs to be in the declaration. I do see it from time to time in the architectural review guidelines. I prefer it to be in the declaration itself as usual. But an appeal really should be to a body that didn't make the original decision, that has the authority to reverse that original decision, amend it, affirm it, that sort of thing. But the word appeal and the idea of an appeal is a relatively misunderstood concept. And it's really important to understand that and what it is, because over time, that misunderstanding can manifest into unequal treatment. And those are the types of things that are breeding grounds for disputes, where lawyers can make some hay about something, and you might be in a compromise situation if you're not managing the appeal process correctly.
And just to follow up on what Alan's saying there with regard to appeals, most of the times, if there is an architectural review committee that's in place, if there is an appeal procedure that's set forth in the declaration or the guidelines or the bylaws, it's going to say that the appeal is to the board themselves. And typically, if there's a member of the board that's also on the architectural review committee, then that person would maybe need to recuse themselves from the decision making. But what happens if you have a board that is the decision-making authority for the architectural review process? Where is the appeal to? Well, that's really a lawsuit. The individual has the right to sue in Superior Court and basically challenge the board's decision in that level. So there's not really an appeal back to the board or anything like that, or you don't appeal from the board to the lower Architectural Control Committee. It's really a lawsuit, and that's where Alan and I end up getting involved is with lawsuits. But let's talk a minute about challenges for the association with regard to enforcement. Alan mentioned an example earlier, and that is any kind of rule that is created, whether it's by the board or a committee, that's difficult to enforce and monitor, basically opens up the association to potential lawsuits and things like that. If you have that standard that Alan was talking about, where it's your Bermuda grass can't be more than 1.5 inches, that's the kind of thing that's going to end up probably getting litigated over at some point, because somebody's going to get upset about it because it's too specific and it's hard to monitor and control. On the opposite side of that, you have vague, or what I call subjective standards a lot of times. We give some examples there of coastal low country, and that's basically some standards that are related to the low country areas in North Carolina, and I'm sure you all are all familiar with them. You can have vague standards like first class construction, workmanlike conditions, and custom construction. The better ones are objective standards. You can have a fence that's no higher than 6 feet in height in your backyard. You can't have a fence in your front yard. Those are types of standards that are probably going to be enforceable and are going to be, if they're put in place properly, because they're objective, they're easy to monitor. The 2,500 square foot of heated space one is probably one that's easily monitored. Having a sufficient amount of garage space, or even having a garage on the property, so that vehicles can be parked out of sight. Those kind of things are more objective than they are subjective, and are less likely to be challenged. Another area is any activity that's trying to be controlled within inside the dwelling or unit. Paint colors on walls of the interior of the building, things like that are not going to go over well with the members, even if they're visible to the outside world through a window or whatever. So you got to keep those in mind, because that's just not going to be the type of rule or regulation that's probably going to be enforceable and upheld by the court. And then sometimes, the question becomes, if the documents that create the architectural review process and the board and the committee's authority to regulate that stuff don't have any kind of provision that allows for inspection rights or easements, then how do you enforce some of these guidelines, especially if it's something that's inside the dwelling? Now, in a condominium context, you're most likely going to have that kind of inspection right, because there's usually limited common areas that are inside units and things like that. But you're not going to see that in a single family residential kind of community. And so the question becomes, how does the board have the right to go on the property? Do they have a right to basically go on and inspect things that are being built on the property? And they may not. So keep those kind of things in mind.
So what are some of the ways that disputes breed, things that associations face? I'm sure a lot of you have had experience with these. We certainly have. Probably the most serious is building without approval or installing something without approval. Eric and I were talking the other day about a case that involved a yard improvement, and an unauthorized, unapproved yard improvement. That case ended up stretching 3 years, involving over $100,000 worth of fines that were ultimately imposed against the property, and just an amazing amount of attorney's fees. And it was such a shame that it got to that point, because these are the building and installation without approval cases are the ones in conjunction with the amount that the law allows a community association to fine, these are the ones that can turn into mutually assured destruction pretty fast. And so building without approval is something that I would encourage all communities, one, to do everything in their power to avoid a member that, doing this, and to meet any sort of sign of building without approval, laying down foundation, the sod is on the truck in the front yard, anything like that needs to be met with immediate action. And I hate to say it, the threat of a lawsuit. The type of lawsuit that you would file in order to stop building without approval or installation without approval is a lawsuit that seeks an injunction, a court order that says, hey, member, you have to stop. And so those are very, very serious things. It is extremely important to pay attention to what is going on in your community and to get out ahead of it. If the thing gets installed or the house gets built or the garage gets built or the driveway gets paved, the case becomes more complicated, because at that point, you're asking the court to tell somebody to rip up something or rip out something that they have put in. They have a cost in it, all that sort of thing. And so the stakes jack up. Similar situation with replacement or modification of an existing, construction or design. Time limits on approvals. These are really something I never like to see in a document. So these are the covenants that require, say, an ARC to respond with an approval or denial or a request for a modification of the application within 30 days. Oftentimes that deadline is missed. We see it all the time. And when it is missed, it means approval. Most of what we see, if that deadline gets missed, it means approval. That is very different from other types of defects in the process, say not having an ARC vote correctly on a denial or something along those lines. So really pay attention to those time limits on approvals, get out ahead of them, incorporate a docketing system, all that sort of thing. If you're a management company, you're going to want to specifically address that on your end if you're going to take responsibility for monitoring the ARC process, because that's a source of potential liability, and you just want to make sure you're all over that. When we're talking about uncertain transfer of authority from a developer or an exemption for developer or builders, I do a lot of work with developers. So does Eric. We work on both sides of the house. Developers can create a lot of problems for community associations with how they handle architectural review. I mean, the whole nature of architectural review is not really for a community so much as it is for a developer to protect their investment, which is one reason they keep a hold of architectural control for a really long time, is because they want the community to maintain a certain quality so that they get the return on their investment that they expect. But developers can create a whole bunch of problems. They're selling homes to these folks who become members. So oftentimes there's a letter out there that says, hey, Mike Scott can build his fence, even if that fence is inconsistent with the covenants, all that sort of thing. One trial that I was involved in, it was terribly contentious and was a split baby at the end of the day, was one that involved a softball trailer up in Smithfield. And the developer had made a representation that these folks could have a trailer, a softball trailer, softball equipment trailer in their driveway. And the whole case became about proving that that representation was either made or not made, who could reasonably rely on it, and all that sort of thing. It was a mess. And so we have written several articles, and this is a whole separate topic, about healthy transition from declarant control or developer control. It's really important that HOAs take a very proactive view of that, try to work with the developer to have a healthy transition, but also understand, unless the developer has been long gone, understand what rights the developer has. We do this all the time where we catalog the declarant rights, the status of them. Have they expired? Have they been transferred? Have they changed? Who holds them now? Understand that. Pay attention to that. And when you do have your arms around it, then you can talk about how to resolve any sort of lingering issues that may be out there.
Alan talked there about time limits for approvals, and there's also another type of time limit that can actually affect architectural approvals in communities, and that's on the owner. There are oftentimes in declarations and other documents time limits that require, if they're building a new home or something like that, or putting up some sort of an accessory structure or things, there's a certain amount of time that they have to actually complete that construction. And that's another area that approvals can, have time limits on them where there can be challenges or the committee or the board can get into trouble, the association. So keep that in mind that those are out there. Some other areas, a lot of declarations these days with stormwater issues basically have built upon area limitations in them. That's a sort of a dual area where there's enforcement by the government agencies over that, but there's also enforcement power for that with the communities. Hopefully, the regulatory agency will get involved and will take on the burden of prosecuting it. But of course, agencies like that are often overworked and sometimes they don't. So, the boards need to stay on top of that. And if there's a built upon area limit and somebody has reached that limit and they go to build an accessory structure or something that puts them over that limit, then the architectural review committee has to be aware of that so that they don't approve it, because then that can create a problem for the community. Arguments over style and colors. I've been involved in a couple of those, and I'm sure Alan has too. Just to give you an example, one involved a house that was in a community with a lot of sort of just bland colored houses, white, gray, things like that. And these people wanted to paint their house hydrangea color, which I didn't know what that color was until I got that case, but it's essentially a bright pink color. And they wanted it to look like a flamingo. And so basically the board, the architectural review committee ended up approving the request for the paint, but with the condition that it be muted by 25%. And of course, there was an argument over whether the paint that actually got applied to the house had been muted to 25%. So, in those kind of cases, it's better, probably not to approve that color choice if there's grounds for that. If there's not, and there's nothing that prohibits that color choice, then the board or architectural committee ought to approve it. But trying to qualify it doesn't often work. Another one that I was involved in was involving roof shingles. The document specifically said and referred to weatherwood, and I didn't know what that was either until I encountered that. It said you can have weatherwood shingles or earth tone colors. Well, the intent of that was to say that they should be brown essentially in their coloring. And the person who put shingles on their roof, one, did not go ask for permission, which was in violation of the rules, but they also put gray shingles on there. Now, their argument was gray or slate or stone is an earth color, but it, again, that one's somewhat subjective, but it just leads to arguments. And finally, I had one that was involving whether a house was stick built or not. The covenants clearly required stick-built construction. These individuals went to one of the log home cabin companies and got purchased essentially a kit. But this building was built from the ground up and it had architectural plans, and it was essentially similar to a stick-built one. But the real issue there was half of the community did not want log cabins in the community, and half of them wanted it to be more like a fishing camp and be able to have log cabins. So, those are the type of things that and challenges that association boards can face and the association can face if architectural standards are not clearly adopted and are hard to enforce. So turn it back over to Alan.
Yeah, I just hear some more issues, pitfalls, that sort of thing. The concept of precedent and selective enforcement are, they really sound in consistency. And whatever the architectural, the evolution of the architectural restriction is in the community, it needs to be consistent. Where judges, I think Eric will agree with me on this, where judges get irritated is when communities single people out, or when they treat people differently or treat sections of a community differently. That's tough to arm if you're the lawyer going to argue that one, that's a hard sell to the judge. And that's not where you want to find yourself. What you want to tell the judge is, hey, judge, these members want to do something inconsistent with the rest of the community and inconsistent with our documents. That's the story you want to be telling. Now, having said that, precedent does not, in my mind, change entirely in a community based on one house and one approval. So there's going to be some variation, and this is a contentious topic in just the HOA world in general. And good lawyers disagree about this all the time. How do you chart that consistency? Does it change if the community's always had blue doors and all of a sudden the ARC approves a red door? Does that mean that every applicant after that red door is entitled to a red door? I would say no. However, we never should have approved the red door to begin with unless the standards were going to be changed. And so if you find yourself in that situation, well, number one, don't find yourself in that situation. But if you do, then I think there are good faith arguments that one approval does not change an entire community. That the idea of a community-wide standard shouldn't be changed by one house. But it does start to chip away at it. Now, if you've got 10 houses and one house changes, then that's more impactful on the community-wide standard than if you had 100 houses and one house changes. And so think about the percentage of those, differing improvements. Situation I had with, while we're on war stories, situation I had with the yard improvement was that 4 houses out of 1,700 houses had a similar, although somewhat different, yard improvement that had been approved over the years. And the argument from our side of the house was, gosh, you can't completely change the community-wide standard or the interpretation of the restrictions with one house or 2 houses or such a small percentage of the community. But those are issues to really, really think about. And they are so much, you are so much better off addressing them proactively before the decision is made and before the improvement is made or the thing installed than trying to deal with it after the fact. If you find yourself dealing with it after the fact, then you need to consider where the guidelines and the restrictions stand and whether those need to be updated. And then also consider how you're going to deal with future applicants that seek the same thing. Defensible denials is the last piece I'll touch on this slide. In North Carolina, prior to a few years ago, all the ARC had to say was denied, period. All the board had to say was denied, period. Send a letter, done. And you could make somebody apply 300 times for the same thing. You never had to give them really any feedback or anything like that. That is no longer the case in North Carolina. There is a case about above ground pools that came out of the North Carolina Court of Appeals a few years ago. And if any of you are interested in it, we're happy to send it to you. And in that situation, the association, their ARC denied an application for an above ground pool. But when they denied it, they didn't really give any help to the member. They didn't tell the member, hey, these are the things that are offensive. These are the things that we don't like. These are the reasons that we denied your application. And there were other above ground pools in the community. And what the Court of Appeals said is, yes, that's fine. But there was a dissent. And the dissenting judge said, come on, guys, that's not fair. The way the law should be is that the ARC or the board, whoever's denying the application, has to give concrete examples and feedback of how and suggestions of how this applying member can achieve approval. Is it too tall? Is it too wide? Is it too deep? Is it not the right volume of water? What is it about this application that is wrong relative to the restrictions? Now, that could be, hey, there's a piece of our covenants that says specifically you can't have X, Y, or Z. You can't have oleander bushes, or you can't have palm trees, or whatever the thing may be. But you can't just say denied. Now, and if you do just say denied, and that is challenged, in that particular case, the application was approved by the court because of the bad denial. So real quick note on procedure, when there's a dissent from a majority opinion, so a judge writes a separate argument in opposition to the majority, that gives you the right to appeal that up to the North Carolina Supreme Court. And what the North Carolina Supreme Court did in that case was actually adopt the dissent as the controlling opinion. And so when we're reading that case, we just read the dissent. So key piece, do pay attention to that. I've seen people get in trouble with that since, and it is a favorite playground of the lawyers to bring that up.
So now we're at the point where you've got your rules in place. The Architectural Control Committee is enforcing the rules and reviewing applications, or the board is, depending on who's handling that responsibility. And you have somebody in the community that doesn't follow the guidelines. What do? Well, you have the opportunity to find those people, send them a notice of violation, and let them know that they are not in compliance with the community standards under the guidelines. And you can either impose fines or suspend privileges and services. And that authority essentially comes from two places. The first place that you have to look at is your declaration. Sometimes the declarations will have a specific procedure in there. And if they do, that procedure is going to govern, because Chapter 47F-3107.1 says in the opening sentence, look at your declaration, and unless the declaration provides otherwise, then these rules apply. And so essentially what I have there, this is a very somewhat busy slide, but it's sort of the procedure that you have to go through once you notice a violation on a lot. There is a hearing that would be held before the board, or the board can create an adjudicatory panel that would be appointed by them. A lot of times it's just the board that ends up handling it, but the board does have power to create that kind of a panel to hear it. If a panel is created, the members cannot be officers of the association, and they cannot be members of the board. So just keep that in mind. And again, that's why a lot of times the board just ends up handling those kind of decisions. The lot owner has to be given notice of the charge, and typically that's got to be done in writing. They have to be given an opportunity to be heard and present evidence, and they have to be given notice of the decision that's made. Under the statute, a fine can be imposed up to $100 for the violation itself. So somebody puts up a fence that's 8 feet tall, and it says the fences can only be 6 feet tall. You send them a notice of violation that their fence is out of compliance. That is basically when you have the hearing and they say, well, we didn't know that we weren't supposed to put up an 8-foot fence. That's not a good defense. They could have read the guidelines and things like that. They could have asked for permission to put up the fence, and you would have told them that it was not going to be 8 feet. But you get to fine them $100 for that violation. But you also get to fine them $100 for each day, more than 5 days after the decision is made. And that language is kind of confusing. But what it is it's given the owner a grace period of 5 days to correct the situation, to go out there and tear down the fence in that 5-day period. But if they get to the 6th day and they haven't torn down the fence, then you can start charging them $100 a day after that 6th day for that, that violation. Doesn't have to be $100. You could, feel that it's a $50 violation or something like that, but it can be up to $100. The fines that are levied become assessments on that lot, and they can be secured by a lien, which can be important. We have seen, I know Alan has seen, fines get up into the tens of thousands, hundreds of thousands of dollars, depending on how long the people let them go and how much they fight them, because those fines continue to accrue while the people are challenging the matter through litigation. If privilege is the other thing that you can do in addition to fining them is suspend privileges and services. And if that's the case, those can also be continued without having to have a further hearing on the violation until the violation is cured. But it has to be done for a reasonable amount of time on those. The lot owner can, if an adjudicatory panel is used, the lot owner does have the right to appeal to the full board by delivering written notice to the board within 15 days. And the board can do one of three things. They can affirm that decision by the adjudicatory panel. They can vacate the decision, or they can modify the decision of the panel. So that's kind of a quick and dirty. Some of the more specific procedures that you want to do is, when you send the written notice of violation, the hearing date has to be more than 10 days. You have to give them at least 10 days from the date of the letter in order to give them time to prepare. And that's probably the most important things. There are other things like the factors that should be considered, but we want to leave some time for you all to ask questions. And so, I'm going to leave it at that for right now, but there are other factors and things that you need to keep in consideration. And so some things to remember.
Yeah, so these are just, just kind of a little recap of what a little roadmap for when you run into these things. Consider all of these points. Specifically point number 5, but don't be reasonable to the point where you're compromising the integrity of the governing documents or the restrictions, because that just muddies the water and makes it more difficult for people to understand where they're supposed to be in the community, how they're supposed to operate within the rules. But run through this analysis when you are faced with these problems, or get a lawyer to help you with that, and see these architectural things for not just what they are, but what they can become. Eric made a point just now on the slide about how fining can work in North Carolina with $100 a day. Guys, it takes 18 months to litigate a case. And so, or more. And you're talking, if you're running $100 a day, you're talking $3,000 a month, $36,000 a year. If it's secured by a lien against a house, you can see where these things get to the point where more than $100,000 is owed. And we have run into those cases time and time again. So best to nip it in the bud early, see things for what these disputes for what they can become, and be proactive about addressing them. And this is a roadmap for how to do that.
And overall, be reasonable about it.
Great. Well, thank you so much, Eric and Alan. And we do have a few questions, so I'll dive right in. This first question does have a little bit of background, so I'll read through that and then pose the question. So the background is our design review committee has only been under HOA control for several months. When we first took it over, we had our lawyer review the DRC document created by our developer and remove any items deemed as unenforceable. We are still struggling to understand why, even though our covenants reference the DRC document as being the control for building in our development, some parts of the DRC document are not enforceable. And the question is, why are some aspects of our document enforceable and others not? And how is that determined?
You want to take that one out?
Yeah, and it's a little difficult for us to come in behind another attorney on a community-specific question. And that's a good example of being right on the border of what we're able to answer and not. I can tell you that there's the doctrine of severability in North Carolina, where certain provisions of a contract, like a declaration of restrictive covenants, can be found to be unenforceable, and that doesn't mean that the entire document is unenforceable. But it is a little bit difficult to dive completely into that because that does seem like a community-specific question, document-specific question.
And I'll just give one other example of that. And we talked about it earlier in the presentation, and that would be, let's say you have an architectural control requirement for the heated space, and it is inconsistent with your declaration because it's more restrictive than what the declaration requires. That could be a reason why that part of your architectural guidelines are unenforceable, even though they've been passed by the board and in the past maybe been applied by the community. But that's probably the best we can answer that, because it is dependent upon specific facts related to the community.
Thank you both. So our next question was submitted live, and it is, in a townhome situation where the unit owners share a common crawl space area, how can the HOA recommend or direct improvements? In a situation where, say, 5 units in a 6-unit building want to improve the crawl space area and one doesn't, how can the HOA push compliance? Does the HOA have oversight or maintenance responsibility in the crawl space area?
Well, with respect to maintenance responsibility in the crawl space area, we just don't know, because you'd have to look at your documents. Understand, though, that the way townhomes are constructed, they're different than a condominium. There's really no, there may be a common crawl space, but where it's connected across the individual lots. But a townhome is actually a single family lot, and the ownership runs into the dirt. And so you may have like a common crawl space, but you're going to have individually owned lots in that crawl space. So for instance, the foundation of a townhome is actually owned by the owner of the townhome. The exterior bricks for the portion that they own is actually owned by that owner. It's usually not common area like you would see in a condominium. And so the homeowners, that's kind of a mixed question about architectural review and maintenance authority. I have seen townhomes that have sort of an exterior maintenance and a crawl space maintenance obligation that's put on the association. I don't know whether that's in play here or not. It may be. With respect to architectural control, you don't see it quite so often in townhomes, but if the documents provide for architectural control, and if they provide for review and approval of improvements to a site, then the association would have authority to exercise that, approval over anything, that's going on in those crawl spaces. But I don't know that there is a way to force that 6th owner to do, to go along with the other 5 owners. And frankly, I don't know that that's something that the association should inject itself into anyway, unless the improvement would affect the association's maintenance obligations and that sort of thing.
I tend to agree with Alan. This is one of those questions where it's going to be dependent upon your documents probably entirely. The end question is, does the HOA have oversight or maintenance responsibility over that crawl space area? And, essentially that's going to depend on what the documents say. If it's a common area, yes. If it's a limited common area, partially, probably yes. And there's probably some shared maintenance responsibility with the homeowner. Like Alan said, townhomes are typically from the ground to the sky with a shared common wall between them. And so that shared wall is probably something that the association may have responsibility for, but otherwise probably not the crawl space. So.
So we did also have two questions come in related to South Carolina law. Would you all like to address those live, or is that something we should look into addressing offline?
That's something we need to address offline.
Yeah, well, we're not licensed in South Carolina, and so
We do have attorneys who are licensed in South Carolina, but they are not on this webinar.
those are tough ones.
Okay.
Sorry, we can't answer those right now.
So we do have a few more. I'll go through those. The next question is, would you be able to fine a flat fee post-hearing?
You could, I think. I mean, you could essentially say it's going to be a one-time additional fine, but it would be limited to $100. It'd be probably limited to 1 day. I don't know why you would want to do that. I mean, the hammer that the association has is the fact that it's a continuing fine. And that gives the owner incentive to get the problem corrected. Otherwise, they just will let it sit. So I don't know that you would want to, even if you could do a flat one-time type thing, I don't think you would want to.
Yeah, I certainly agree with that.
The next question is, if a resident has multiple violations, can he or she be assessed $100 per day per violation? If we then get a lien against the property, does that mean we are powerless until he or she tries to sell, or can we initiate foreclosure?
Well, so to answer the first question, as long as the violations are distinct, you can have enforcement for each distinct violation. Now, I've seen associations try to get a little cute and say that, you know, for instance, leaving your trash can out and leaving your recycling bin out is really two separate violations, which means $200 a day. I would encourage people not to try to get cute like that. But if one is cutting, you know, installing a tree in an unimproved place, and the other is leaving your trash can out for days on end, then yes, I do think those are two separate violations that you can run separate fines for. But you need separate hearings and all that sort of thing too.
And I'll give you, you can have, I think, one hearing with multiple violations, but you have to include them all in the notice. They have to be specifically noticed. And I'll give you a great example. The guidelines require architectural approval from the committee or from the board. The people don't submit plans and they don't ask for architectural approval. That is a violation. They then go ahead and build whatever they wanted to build on the lot. That is a second violation, the actual building of it. So you could have, they could cure the first one by submitting a set of plans to the Architectural Review Committee for what they built. But the other one is a continuing violation until they either tear it down or make it comply with the covenant. So that's how you would have two multiple type of violations also.
And I think there was a portion of that question that went to the enforceability of the lien, the utility of the lien. What does the lien do for you? So let me take that in two parts. So one is what does the lien do? What is the effect of filing the claim of lien? Number one, it secures the debt. It's just like a deed of trust on your mortgage. It secures that debt against the property and serves to encumber the property. It prevents the owner from getting like a refinance or something along those lines. It's going to junk up any way that the owner wants to use the property. If the owner goes to sell the property, then the buyer's attorney, which in the real estate closing world, the attorney represents the buyer. The buyer's attorney is going to seek to have that lien paid and dismissed before the buyers will take title to it, because if they take title to the property and the lien is not resolved, it becomes their responsibility too. The secured part of that goes to them, and then the selling owner still has an unsecured debt. So it's a situation that usually causes the lien to be paid quickly, but that you don't have to sit around and wait for that. There are, with respect to just the claim of lien, the association can move forward with foreclosure. That's a grave remedy, and we've actually got some collection strategies that we employ as a firm that don't necessarily go the foreclosure route right off the bat. The reason is it's complicated. You end up owning the property. pay taxes, all that sort of thing. You're really not in the business of owning property. But the thing I would mention is the claim of lien is just a tool to secure the debt. The association can also bring a lawsuit to recover the debt, just like if it was Visa and Visa wanted to, had a default credit card and account and moved to collect on that balance. The association can do the same thing. And then you can get a judgment, and the judgment operates just like a lien as well. Some of that collection stuff can get pretty complicated, and we spend a lot of time working with clients on the specifics of that. But the quick answer to your question is absolutely not. You don't have to sit and wait. A claim of lien is a very, very good tool to have in your belt.
Yeah, and I would agree with Alan that foreclosure is one of those things that has a lot of different variables, and it can be done, but is it cost effective to do it? Tends to not be, unless you get into those tens of thousands of dollars where, because you usually have other liens on the property that may have priority and things like that. And then you end up, if you are successful, you end up being the owner of the property. So there's a lot of considerations in that, and there are other things that we can do to try to ramp up some pressure on the owner.
Great. Well, thank you both so much. We are over time, so I'm going to go ahead and close things out. We knew we would have a lot of questions, and we will take those into consideration. You may hear from Eric or Alan following the seminar with some answers to those remaining questions. So thank you again to Eric and Alan. For those of you in attendance following the webinar, you will be sent an email with a list of articles. Oh, yes, sir. Oh, I thought you were.
No.
I'm sorry.
Thank you for everybody attending.
Gotcha. We will send an email with a list of articles related to the issues discussed today, a recording of the session, and a link to sign up for our community association's alerts. We so appreciate you taking the time to join us and hope you're able to take some of the information you learned today and apply it to your own associations. Thank you again, and that concludes today's webinar.